On Thursday, May 16th, the Karen Reed murder trial saw day 13 as we continued through the prosecution's case in chief. On this day, because it was a half day, we only heard from two witnesses. Those were Colin Albert, who continued his testimony, and Matthew McCabe. I was really curious to see how the defense managed Colin's cross-examination, and it did indeed have some fireworks, as they were able to admit some damaging videos. How damaging were they to the prosecution's case? Keep watching, and in the end, I want to know what you think. Let's get into it. Now, the first thing to actually happen for the day was the defense requested to be heard on an issue that came up the day before. You might remember that in the Day 12 recap, I said that the judge determined that the defense had opened the door for Allison McCabe to testify to harassment that she and her family had received. So the defense wanted to make that argument on the morning of Day 13 to have Allison's testimony on that stricken from the record and the jury given an instruction to disregard it. David Yannetti basically said, "We did not open the door. We merely asked the witness when was the first time she handed over the screenshot of those text messages. We've done this with every single witness who provided evidence. We asked when they provided it. We didn't talk about harassment at all. We've specifically stayed clear of the subject so that we don't open the door." Now, in response, the prosecution argued that they absolutely opened the door because basically the questions posed to the witness were geared more towards why she didn't supply these text messages. And ultimately, Judge Canoni said that she remembered the line of questioning clearly and that she very strongly disagreed with the defense, so she was rejecting the request to strike it from the record. Now, for my part, I disagree with the judge here. Although I do think that Allison McCabe's emotional display on the stand was sincere, it was not something that should have come in my opinion. Typically, to open the door to something like that, the other side has to do something pretty egregious to knowingly ask about something that they requested to keep out. Opening the door is basically a good for the goose, good for the gander kind of argument. In other words, when a judge says that one side opened the door to some testimony, it usually is an extraordinary situation where one side has requested that evidence be kept out, and then they themselves basically brought it up. In the Depp v. Heard trial, there was a similar instance where Amber Heard was on the stand and referred to having heard about an incident that Johnny Depp had with a prior lover having to do with some stairs. This was a reference to Kate Moss, and Kate Moss was someone who previously the defense had argued should not be able to testify. However, with that reference, Johnny Depp's team was allowed to bring in Kate Moss, and she did in fact end up testifying in order to rebut that statement that Amber Heard herself made on the stand. So that's an example of a proper instance where someone has actually opened the door to some testimony. But here, it doesn't necessarily follow that the reason Allison waited to provide that text screenshot is the same reason for her general reasons for wanting to provide it at all, which would be, I guess, the harassment. And so there's nothing in the question about the timing of her providing it that should have led to the response, "Well, we're getting harassed, which is why it took me so long to hand this over to the police." It simply doesn't follow, in my opinion. But that is ultimately what the judge decided, and this isn't the first or the last time that I will disagree with a judge's decision. And if Karen Reed is in fact convicted, this is the kind of decision that could very well be determined to be reversible error if and when the defense decides to appeal the verdict. Anyway, then much of the day was dedicated to the cross-examination of Colin Albert. Alan Jackson from the defense immediately jumped in to grill Colin on who he may have talked to about his testimony or about the testimony of other witnesses. And early on, he basically called Colin out for something that the Legalbytes chat has now adopted as cross-examnesia.
So you have no independent recollection as you sit here the last time you talked to one of your best friends and your cousin about any subject?
No, I don't remember.
Were you ever told in preparation for your testimony, if you start to get stumped or nervous, just say, "I don't remember"?
Nope.
Nobody ever told you that?
No. No, sorry.
It's okay. So nobody ever informed you that you might get nervous on the witness stand, there might be tough questions. The easiest way to get out of that is just say, "Yeah, I don't recall."
No.
So you just don't recall because your memory is that bad. You literally don't recall the last time you spoke with a cow.
Objection.
Ask that differently, Mr. Jackson.
Sure. Your testimony is you were not instructed to say, "I don't remember." You just literally don't remember.
Correct.
It's an issue with your memory. not an instruction that you received.
Correct.
Right.
Jackson also brought in more evidence of the family connection between the Alberts and the Proctors. Specifically, he brought up but did not introduce a photo of Colin as a young ring bearer for the wedding of Courtney Proctor, the sister of Trooper Michael Proctor. And Jackson pointed out that Colin was only interviewed by the Massachusetts State Police, not Canton PD, and that was by Trooper Michael Proctor and one other trooper. This was in July 2023, almost a year and a half after the incident, and it lasted about 10 minutes apparently. Next, Jackson brought up the text that came up in day 12. He established with Colin that texting was his preferred mode of communication, and particularly with Allison McCabe. And so Jackson pointed out that after January 29th, 2022, there is a gap of about a month in the texts between Colin and Allison. And the suggestion here is if the two of them text a lot, why such a substantial gap?
You see what's displayed on the screen?
Yes.
It's only part of the text string, but does that look like it's an accurate representation of what you're looking at?
Yes.
And this is a series of texts on or about January 28th and 29th of 2022, is that right?
Yes.
And Mr. Albert, you needed something as simple as a ride. You were just asking Allie to give you a ride, is that right?
Yes.
And that's because you said that it's common for you guys to text back and forth. You just texted her, hey, you can get me now, is that right?
Yes.
And then you texted if it's easier, and then she said, okay, I'm dropping people off, and there was an exchange back and forth, is that right?
Yeah.
And there were at least 8 texts between the two of you, if you just count them up real quick, just about getting picked up.
Yeah.
But if you scroll down a little bit, after the end of that text string, that ends at 12:10 a.m. and it says okay. You see the next date?
Yes.
What date is that?
February 20th.
That's nearly a month later, correct?
Correct.
So there was a gap after January 29th, 2022, when you found out that a man had ended up dead on your uncle's lawn, and you and Allie did not text each other for a month, not once.
Objection.
Sustained is to that form. Ask it differently.
Isn't it true that on January 29th, later in the day, you found out about John O'Keefe and his condition, the fact that he died?
Objection.
Is that true? Did you find out that day?
Yes.
Okay.
So you were well aware of, thank you. We can take that down. You were well aware, Mr. Albert, that something very tragic had happened at your uncle's house, Brian Albert's house, right?
Correct.
And you were aware that you had been at your uncle's house that night, right?
Correct.
You're also aware that, according to you, Allie McCabe was the one that picked you up and took you from that location.
Correct.
And notwithstanding the fact of this tragedy, you and Allie didn't text each other one time for a month. Is that right?
I don't think that's correct.
So where are those texts?
We text on other platforms too. So I'd say other apps.
So is there a reason why you decided for the next month to just switch platforms to maybe Snapchat?
Objection.
I'll allow it.
No reason.
Are you sure that you switched platforms?
I'd say so, yeah.
Why did you switch platforms?
We go back and forth, I'd say, between platforms texting.
You switched platforms because you know that Snapchat deletes all communications, correct?
Objection.
Ask it differently, Mr. Jackson.
Do you know that Snapchat has an auto-delete function on it?
If your app is set to that, yes.
Now, on the one hand, this does look like there could be deleted texts between the two of them. The timing of the drop-off of these iMessages is interesting to say the least. But on the other hand, Colin's response that they jumped around between apps regularly to include Snapchat actually sounds to me like a pretty reasonable response. Anyway, then the cross-examination got into some spicy territory. Here, Jackson focused on a series of occurrences where Colin Albert appeared to have bruised or cut knuckles on his right hand. And he brought these in response to some photos of Colin that were shown on direct examination about a month after John O'Keefe died.
You were shown a photo yesterday of you in February of 2022 with your aunt. Remember that photo? Yeah. Mr. Lally showed you that photo?
Correct.
And he said he wanted you to pay special attention to your face and hands and extremities. Asked you if there was anything unusual about that.
Yes.
You said no. In that photo, absolutely nothing unusual in February of 2022 about you, your face, your hands, fists, nothing, right?
Correct.
I want to draw your attention to February 26th, same month, less than a month after the incident. You were at a place called Fenway Johnny's with your buddies, weren't you?
Correct.
Your Honor, I have two documents I'd like to mark for identification with the court's permission to show to Mr. Lally.
Okay.
Sir, do you recognize those two documents?
Yes.
Taking a look at the one that's got multiple documents on it, I don't want you to tell me what's on it. Just tell me if you recognize the picture that's in the middle to the right.
Yes.
Okay. And then looking at the second document, which I believe is marked EE for identification at this point, does that appear to be a true and accurate enlargement of the first thumbnail?
Yes.
And those were taken on that photo was taken on February 26, 2022.
Yes.
At the place called, I think it's called Fenway Johnny's, right?
Correct.
Okay. May I publish the...
Put it into evidence first.
Move for the admission of just EE.
So you need to get it to the court reporter.
Do you see that photograph that's being displayed?
Yes.
Are you in that photograph?
Yes.
Which person are you?
In the middle.
Just a second. And about what time of day was it? That's you in the middle?
Correct.
Okay. About what time of day was this taken?
Not sure.
Was it at an event of some sort or just you were at a bar?
Just at a bar.
Okay. I want you to take a look at your right hand. Can you see from there clearly your right hand?
Yes.
What do you notice about your right hand?
It's cut up.
Your knuckles are injured, correct?
Correct.
Now, you didn't take this photo, did you?
Nope.
That photo was never on your phone. In other words, it wasn't a friend of yours that took the photo, correct?
No.
This was taken by an event staff member, is that right?
Correct.
It was later posted on social media, isn't that right?
Correct.
You could not access the metadata, you couldn't access the time and date of that photo, correct?
I'm not sure what you mean by
You
that.
couldn't manipulate the time or date this photo was taken?
No.
This photo is completely sort of out of your control, isn't that right?
Correct.
And it was controlled by the event staff at Fenway Johnny's.
Correct.
And on February 26th, less than a month after the incident at Fairview, that's what your right knuckles look like, correct?
Correct.
And this is a true and accurate depiction of your condition on or about February 26th, correct?
Correct.
Now, when Jackson asked Colin how he got this injury, this was his response.
How'd you get those injuries, Mr. Albert? We can pull the lights up.
I was at a party, a house party my senior year, and I remember it being icy out, and it was kind of like a steep hill of a driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I had tried to brace myself with my right hand, and I ended up sliding a little bit down the driveway.
What'd you have in your left hand?
If I remember, it was either my phone or a beverage.
So, according to you, you fell on ice and injured your knuckles, as we just saw in that photograph, right across the top of your knuckles.
Correct.
Okay. So you fell onto, what, pavement, asphalt?
Yes.
And you braced yourself when you fell, your entire body weight, by putting your right hand down in a fist, and you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
Objection, Your Honor.
Sustained.
You didn't put your palms down when you fell?
No.
You felt your entire body weight on your right fist and just injured the top portion of your knuckles, correct?
Correct.
Those injuries to your knuckles look an awful lot like the type of injuries that you would get in a...
Objection, Your Honor.
Sustain.
You ever been in a fight, sir?
Other than with my brothers, no.
Now, I don't know about you, but I have fallen before and had to break my fall with my hands. And in my experience, the human instinct is not to land on your knuckles with a closed fist. That actually seems like a very easy way to break one of the many small, fragile bones in your hand. And although I'm not any kind of a medical expert, of course, it seems to me the human instinct is rather to fall with an open palm, which allows you to absorb more shock with your muscles and your tendons. Now, of course, when people fall, are they sometimes unsuccessful in catching their fall? Yeah, of course. But, I don't know. This just sounds like a terrible explanation. And it's really just...
Suspicious. Don't be 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 suspicious.
John Ralphio?
Now, Colin's response here also opened the door to further evidence to be introduced by the defense. These were 2 videos of Colin with some spicy words for some other guys that he was interacting with one night. Now, before I play them, I will say that in court, there was no censorship of any cursey words to speak of. And normally I do censor these words because of the YouTube algorithm. But because those words were kind of important to the cross-examination on this point, I'm actually going to leave them as is. So if that's something that offends you, brace yourself.
Mr. Albert, before we took a break, you had mentioned that you've never been in a fight.
Correct.
You stand by that testimony?
Correct.
I'd like you to take a look at a video. It's been marked for... Sorry, it's evidence number 86. I'm going to play this short video for you, and then I'm going to ask you a couple of questions.
Yo, you're Benton's boys. I will beat all your asses. I promise you, I will fuck you all up. Pull up, bitch.
We have the lights. Did you recognize what was depicted in that video?
Yes.
Who was that?
Me.
Approximately when was that video taken?
Around my sophomore year in high school.
Sophomore year or senior year in high school?
Say around my sophomore year in high school.
Why do you say your sophomore year when you previously... Well, let me ask it a different way. Did you previously testify at a different hearing back in July of 2023?
Yes.
You were asked about this video, weren't you?
Yes.
You were asked about another videos at the same time, correct?
Correct.
And in that hearing, you said you believe that was taken closer to your junior year or senior year in high school, correct?
Correct.
And that was under the oath?
Correct.
Same oath that you took here?
Correct.
Closer in time to the events in question, and at that time you said your junior year or senior year in high school, correct?
Correct.
If it was your senior year in high school, what year would that have been?
21, 22, so 2021, 2022.
Going into 2022, correct?
Yeah.
The same year that John O'Keefe passed away.
Correct.
What did you mean by, I'm gonna fuck you up?
That I was going to beat them up?
Actually, you didn't say beat them up. You said, I'm gonna beat your ass, didn't you?
Yes.
That was a threat, wasn't it?
Yes.
It was a threat directed at some other individuals with whom you had some sort of a beef or a problem.
Correct.
And your resolution of that problem is, I'm gonna fuck you up, I'm gonna beat your ass, right?
Correct.
But you've never been in a fight.
Never.
Your Honor, with the court's permission, could we play evidence number 87?
Yes.
You're a bitch, bro. Fuck you. Yeah, fuck you. Good code, boy. You be knocked out. KO. Bang, bang.
Lights. May I inquire?
Yes.
Mr. Albert, who was that in that video?
Me.
Was that taken around the same time?
Yes.
You indicated You're a bitch, bro. Right?
Correct.
Was that a threat?
Yes.
More of an insult?
Yeah, more of an insult.
Calling someone out?
Yep.
Making them feel bad?
Yeah.
Prompting them to maybe fight?
Objection, Your Honor.
Yeah, I'll ask that question differently, Mr. Jackson.
Also called him a pussy, didn't you?
Correct.
Derogatory comment?
Correct.
And then you said, KO, bang bang, right?
Correct.
What's KO mean?
Knockout.
And what does bang bang mean?
I'm not sure, honestly.
You were just talking about knocking somebody out,
Correct.
and the bang bang just sort of flowed.
Exactly.
Was that a threat?
Yes.
And these threats that we've just talked about, that we've just seen, these are threats of physical violence, right?
Correct.
You're not threatening to hurt their feelings or send them a mean text, right?
No.
You're threatening to kick their ass, right?
Correct.
To get physical, right?
Yes.
To ball up your fists and beat the shit out of them.
Objection.
Can you answer that? Will you answer that, please?
Yeah, can you repeat the question?
Probably shouldn't. You were threatening to ball up your fist and beat the heck out of them.
Objection.
I'll allow it. Is that what you were threatening to do?
Yes.
Now, these videos can also suggest the following. Colin is a punk who talks a big game, but never actually gets into any fights. Simply put, we actually don't know what really followed these videos. Did he actually fight the other guys, or did nothing come of it? Either way, one thing that I will say is that this does show Colin being aggressive in the past and apparently while drinking. Whether the jury decides that that adds weight to this particular case is of course up to them. Now, Jackson also brought up how Colin attended a hearing in July 2023 and apparently showed up with busted up knuckles on his right hand. And Jackson grilled him on the questions that were asked of Colin about that hand at the hearing.
When you testified in a separate proceeding in July 2023, you actually showed up for questioning live, correct?
Yes.
And you showed up at the time in July of 2023 with your knuckles busted up again, didn't you?
Correct.
And you were asked about your knuckles at that time, correct?
Correct.
And that time you said, oh no, I didn't fall down on black ice and slip and break my fall with my knuckles like you said here. You said, oh, I hit a heavy bag and busted my knuckles up on a heavy bag, right?
Correct.
So that heavy bag was you practicing boxing, right?
It was me getting cardio, yes.
Which is in a form of fighting.
In a form, yeah.
Punching a bag.
Yep.
That's how you choose to do your cardio.
Sometimes.
And you're right-handed,
Yes.
and it was your right hand that was busted up.
Correct.
So when you throw your hardest punch, that's with your right hand, isn't it?
I'd say, I'm not sure. I'd say they're equal.
You're equally strong with both hands.
I'd say so.
So in your words, you could fuck somebody up with either hand, right?
Objection, Your Honor.
You answer that?
No, I'm not saying that.
That's all I have.
So now Colin has two instances of having a busted hand and two different explanations for each one. And of course, there is a possibility that both of those explanations could be correct, even though they're different and the injuries kind of seem to be very similar. But I will say I do have limited knowledge of boxing, coming from my own admittedly short stint in taking boxing classes for a while. All of my experiences have been wrapping my hands for boxing, but I do understand that there are people who will box without wrapping their hands. And I suppose one advantage of this that I've heard of is that over time you can increase the strength of the bones in your hand and particularly your knuckles. Okay, I'm willing to accept that. It is strange, however, that Colin seems to be saying that his cardio was hitting a heavy bag without wrapping his wrists and seemingly only with his right arm. And so to me, this cross-examination overall was very successful in giving the jury a very different picture of Colin. But I'm very curious to hear your thoughts in the comments down below. How damaging was this for the prosecution? Let me know. Okay, so that was Colin Albert. The next witness and the other witness for the day was Matthew McCabe. He is the husband of Jennifer McCabe and the father of Allison McCabe, who of course testified on day 12. Most of Matthew McCabe's testimony on day 13 overlapped with other people that we had heard earlier. He was at the waterfall with everyone else, people were drinking and having a good time, as basically everyone else has put it. He and his wife Jen McCabe arrived around 9 p.m. and left just after midnight to go to 34 Fairview Road. He also testified that John O'Keefe and Karen Reed came in at about 11 p.m. Matthew said that he wasn't really paying attention to how much anyone else was drinking at the waterfall, but he himself drank somewhere around 3 to 5 drinks there. As for Karen, like everyone else, he testified that she was drinking a tall, thin glass with clear liquid and a lime. And like everyone else, he said that it was vodka, but couldn't provide any basis for thinking so other than the fact that the liquid was clear. In fact, he even said on the stand that he assumed it was vodka. Towards the end of their time at the waterfall, there apparently was a discussion about whether to go to 34 Fairview Road or whether to go to D&E Pizza, the pizzeria owned by Christopher Albert. Karen was apparently insisting that they go to D&E Pizza, but that's obviously not what happened that night. Anyway, Matthew McCabe said that he and Jen arrived at 34 Fairview Road around 12:20ish and that they stayed until about 1:45 a.m. In between the waterfall and their arrival at the 34 Fairview Road, apparently John had texted Jen for the Albert house address. She called him back to give them the address and general directions. Anyway, Matthew testified that when they arrived, he never saw Colin Albert at the home that night. He also said that within 3 to 5 minutes of arriving, Brian Jr.'s friend, Julie Nagel, said that her brother was there to pick her up. Around there, Matthew said that someone else had mentioned another vehicle being out there, which sparked Matthew's curiosity since he was expecting John to show up. So he testified he got up to look out the window. And he testified that he ended up looking out 3 or 4 times. The first time there was a dark-colored SUV outside right squarely in front of the house, basically by the mailbox. About 2 to 4 minutes later, he said he looked out again because he thought it was weird that John hadn't come in yet. That time, he said that he saw the SUV had moved over by the flagpole and the fire hydrant area and noticed that there was a dusting of snow on the ground. Some, but not all that much. He said he thought to himself, WTH are they doing? And went back to sit down again. Then he said he looked out a third time, this time after Julie Nagel had come back inside. And this time he says that the SUV moved further over more towards the edge of the property line of the neighbor's house. And this time he said that he noticed some abnormal tire tracks in the snow.
With respect to the snow that had fallen on the ground, as far as the vehicle was concerned, it moves from one point to the second point to the third point. Do you observe any sort of tire marks or anything in the snow out on the road when you looked out?
Yes, I did.
And the tire marks that you observed, did they essentially lead up to the back tires of the dark SUV that you saw out there?
At some point, I looked out and noticed tire marks that would have started before the Jeep. So if the Jeep was here, it's just a weird, like a wave. It was a weird wave in the road. You could see the tire marks.
And was that before or after? So at some point, Ms. Nagel goes out to some other vehicle and then comes back inside the house, correct?
Yes, that's correct.
You know about how long she was outside of the house for?
I'd be guessing a minute. I'm not sure.
Just not terribly long time?
No, not at all.
And so the time that you observed this sort of abnormality in the tire marks that you see out there, was that before or after she had come back inside the house?
That would have been after.
So you don't know if that was from the dark SUV or whatever vehicle she had met. You have no idea.
Objection. No. Can you answer that? Well, the form of the question, it's sustained then.
Do you know which vehicle left those abnormal tire marks you saw?
Based off of where the tire marks were, they came off the curb, my assumption was it was the SUV.
I withdraw.
Okay.
I heard the answer. I withdraw.
Okay.
But you don't know, correct?
No, I didn't see no.
And that was my next point. As far as when you saw the vehicle, as far as each of those 3 times, it was stationary each time you saw it, correct?
The first 2 times, definitely stationary. The third time looked stationary. If it was going a half mile per hour, I'm not sure, but It was further up the road. It looked to me it was stationary, but like I said, if for some reason it was moving, it could have been moving.
Now, Matthew said that he never saw anyone outside, and also that he saw no footprints in the snow that would seem to suggest that someone had gotten out of that SUV. And unlike the 3 witnesses in the pickup truck, he did not see anything inside the SUV. And when he peeked out the window again a little later, the SUV was gone. He said that his wife Jennifer was trying to communicate with John as to where he was, but got no response. Anyway, he then testified that they had left around 1:45 or 2 a.m. He drove his wife, who sat in the passenger seat, as well as Sarah Levinson and Julie Nagel, both of whom were in the back seat. And he said that due to the snow, he had to wipe the car off with his hand and started the windshield wipers before getting started. Now, when leaving, he said that he did not notice anything out of the ordinary, but that he also was mostly focused on driving carefully in the snow coming down. He said that when he arrived at home, it was about 2:10, 2:15 a.m., and basically went to bed while Jen wanted to watch a show to unwind. Then on the morning of January 29th, 2022, he said he was awoken by screams in the bedroom. And that's where it left off. On day 14, we will be getting the rest of his direct examination as well as his cross-examination. Now, as for day 13, I think the defense definitely got a win over getting those videos in during Colin Albert's cross-examination. And those abnormal tire tracks that Matthew McCabe testified to are very interesting. The prosecution seems to be suggesting with those abnormal tire marks that Karen Reed hit John O'Keefe immediately after the pickup truck left. Personally, I don't know if I buy that timing, especially with multiple people noticing that there was an SUV out there and occasionally checking in on it, and yet not hearing any kind of collision or anything. But I recognize that opinions can completely differ. So what do you think? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily coverage of the Karen Reed murder trial, both with our daily recaps and with our daily gavel to gavel live streams, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. See you for day 14.